Shri Radhey, Progressive Shorthand, Legal Exercise 8, page number 17, dictation 80 words a minute. Ready. The possession of the premises to be delivered by the tenant to the L&DO and not to its landlord. We have on Dimmer asked the senior counsel for the appellant whether the appellant is willing to hand over possession to the L&DO, if not to the respondent bank. The answer is in the negative. The said conduct of the appellant demonstrates the malafide of the appellant in seeking to retain possession of a valuable property in the prime central business district of the capital city of Delhi on some pretext or the other. The judgment in Bharat Sales Limited Supra turns on its own facts. That was a case under Section 14 of the Delhi Rent Control Act 1958 and in which proceedings the L&DO was also a party. Such is not the case here. On the contrary, the plea of the L&DO has already been negatived while confirming the sale in favor of the respondent bank. The L&DO having not taken any steps till now for repossessing the property, the appellant cannot wriggle out of eviction order if otherwise found to be validly passed by setting up a title in the L&DO. Moreover, the respondent is a nationalized bank and the L&DO has a policy of revoking the re-entry upon the reasons on account whereof re-entry was affected being remedied and the charges therefore being paid. Para. There is nothing to suggest that the said charges cannot be recovered from the respondent bank. We therefore do not find any merit in the said ground of challenge. As far as the second ground aforesaid of challenge in concerned, the finding of the premises being required by the respondent bank is a finding of fact not interferable in writ jurisdiction, much less in an appeal arising therefrom. The appellant admittedly is an old tenant in the premises at a meager rent. This court is Liar and Son Private Limited versus LIC of India, affirmed recently in Life Insurance Corporation of India versus Damayanti Burma, has held a public sector bank as the respondent to be fully justified in endeavoring to earn maximum out of its properties. Full stop. No case, thus, for interference with the findings of the state officer affirmed by the district judge of the requirement of the premises by the respondent bank for its own use in made out and entitled to retain possession thereof. Full stop.